Should a plumber who's electrocuted on a job site and falls off an inadequate ladder get summary judgment on Labor Law 240? To find out, you have to read Cutaia versus Board of Mgrs. But it's 16 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, Court of Appeals cases in 5 minutes or less. This is the episode on Cutaia versus Board of Mgrs. It can be found at 2022 New York Slip Opinion 02834. It's also a copy is included in my description. Published by the Court of Appeals on April 28th, 2022. The issue in this case is Labor Law 240 and summary judgment on liability under that section. To understand this case, you have to understand those two things I just mentioned, Labor Law 240 and summary judgment. Labor Law 240, along with 241, are both basically about keeping a job site safe for construction workers. And Labor Law 240 says, and specifically, let me just start off by saying it excludes homeowners of one family and two family homes. But apart from homeowners of one and two family homes, the contractors that employ construction workers have to make those construction sites safe. And what 240 says is that there's liability imposed on the contractors, the owners, and the agents, excluding the homeowners, for erection, demolition, repairing, altering, painting, cleaning, pointing of a building, if they don't provide and furnish scaffolding, hoists, stays, ladders, slings, and ropes, basically to provide protection from falls. It was a significant enough issue that people were falling on job sites and getting hurt that they imposed this liability under Labor Law 240. And the second thing you have to understand is CPLR 3212. CPLR 3212 is the summary judgment statute. And summary judgment basically says that as a matter of law, we don't need to go to trial because as a matter of law, Judge, I think that I prevail on this particular issue. And you can do a summary judgment on pretty much any issue. And basically takes it out of the trial and says, as a matter of law, I should prevail. And therefore, it's not an issue for the jury to decide. It's a matter of law, not a matter of fact, because trials are for issues of fact. And basically, a court should grant summary judgment on an issue if the moving party sufficiently establishes that the cause of action or defense warrants that it prevail as a matter of law. And it denies it if there are facts, if any party shows facts sufficient to require a trial on the issue. And basically, it's a burden shifting issue. The moving party has to demonstrate there's no triable issue of fact, and the party's entitled to summary judgment. And if they satisfy that burden, the burden shifts to the other side to show there is a triable issue. Okay, so what are the facts here? The facts are that there's a plumber. The plaintiff is a plumber working on a job site, and his job on this particular day is to go into a bathroom that's under construction and work in a drop ceiling and reroute pipes. And the ceiling has pipes that have water and also have electrical wiring. And the what he has to help him get to the height that he needs is an A frame ladder, a ladder that goes out like this and locks. Locks in the middle. Looks like an A when it's locked. But he doesn't have sufficient room to set the ladder up with an A like this. So what he does is he lays it up against the wall, which is not the way A frame ladders are supposed to be used. And he's working on the ceiling, and all of a sudden, an electrical line in the ceiling touches the pipe he's working on, soldering, and he gets shocked. He falls off the ladder. He's injured. His counsel moves for summary judgment on liability. The trial judge grants partial liability on Labor Law 241, which is not relevant here, and denies it on Labor Law 240, and that's what goes to the Court of Appeals. And the issue here, and there's a majority and a dissent here, the majority says, and the question here is, on those facts presented, that the plumber had to use an A-frame ladder, but put it up against a wall, that testimony at deposition, plus an expert affirmation saying that that the ladder was not appropriate and that he needed different scaffolding, is that sufficient to get summary judgment, as we just described it, as a matter of law? And the majority, which is a 4-person majority versus a 3-person dissent, says it's not sufficient, that there's tribal issues of fact here. The issues of fact exist as to whether the ladder failed to provide proper protection, whether the plaintiff should have been provided with additional safety gear, and whether the ladder's inadequacy was the proximate cause of the accident, or was the electrical shock the proximate cause and the ladder had nothing to do with it. But the dissent by Judge Wilson and 2 other judges that join, Judge Troutman and Judge Rivera, say, make it much more of a strict liability kind of an issue. They say, well, you only have to shoot two things. The statute was violated and the violation was a proximate cause of the injury. The electrical line, the electrical shock is a red herring. Judge Wilson and the dissenters say it was an A-frame ladder. He shouldn't have been using the A-frame ladder. He used it in the wrong way. They didn't provide him the right scaffolding or man lift or, some kind of device to get him high enough and safely. Done. So that's the case of Cutaia versus Board of Managers. Too long, didn't read, 5 minutes or less. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.